are for special needs planning for loved ones with disabilities. I want to introduce our local expert, Mr. Patrick Riso. Mr. Riso was born in New Orleans. He graduated from UNO and Loyola Law School and is currently with Shahardy Sherman Williams.
That's right.
So there's a page with his information in the packet that you received. He has many awards and distinctions, and I just wanted to say, most importantly, he is our board certified tax law specialist and board certified estate planning and administration specialist, which are designations awarded by the Louisiana State Bar Association. There's more information in your packet about Patrick, and I'm going to turn things over to him to get started with our seminar today.
Okay, thank you, Karen. Good afternoon, everyone. I'm Pat Riso. I've done this presentation for Stark many times. Just so there's no misunderstanding, I'm not a financial planner. I don't sell insurance. I'm not here as any sort of a sales pitch. I'm here to give back to the community since it makes up a large part of my business, and I feel guilty. So I'm happy to do it, but don't feel like this is to take to your own lawyer. I'm not here looking for clients, so please understand that. The outline that you have on your table I'm not going to stand here and read that and go through it for you. That's for you to read later. Instead, I'm going to use the time to teach you what I can, and my goal is to explain it to you well enough that you could explain it to somebody else. And if I get there, then that was worth it for me to come over here. Okay. All right, so the first thing I want to cover, and this is sort of kind of what we're fighting for, and that is what is referred to as public benefits. And on the last page of your outline, you'll see a chart. And I've designed it intentionally like this, with SSI with Medicaid next to it, and then SSDI with Medicare next to it. The two at the top are for poor people. The two at the bottom are for rich people. What I mean by that is you don't have to worry about keeping them poor. So the first little roadblock or confusion parents run into, parents or brothers or sisters, whoever, if you're taking care of a disabled person, or if you are a disabled person, is the acronyms and the similarities. It's very confusing. People say Medicare when they mean Medicaid and vice versa. They say SSI when they mean SSDI. I have parents whose children have been on one or the other, and they don't know. I'll say, what does your son receive? And they'll say, he's on SSI. And I'll say, well, how much is the check? And they'll say, it's $1,400. And I'll say, well, sir or ma'am, I can assure you that's not SSI. And so we might debate it a little while, but when I explain that the maximum SSI is $794, well, then it becomes more clear. So you see, you can't confuse them. The two at the bottom, I've had clients call, or people call and say, we need a special needs trust, or what are we going to do? My mother died. And I always start with, well, what benefits are they receiving? Because if it's just SSDI, we don't need to worry about special needs trust. SSDI stands for Social Security Disability Income. You can get it based on your own work record. Your son or daughter or brother or sister might work somewhere, may have put in enough quarters. There's a little complicated formula about how many quarters you have to have worked in the last 10 years, but a lot of disabled people draw SSDI on their own work record. But the other thing that's often overlooked and few people know, other than perhaps y'all, is that when a parent dies, retires, or becomes disabled themselves, the child can draw on their benefit and get SSDI as long as the child was disabled before age 22. Now that gets complicated. You know, there might be people who have a mental illness that doesn't really manifest itself until their 20s or even 30s. So those, we can't really prove that they were disabled. So if you have any children approaching the 22-year mark and you don't have some pretty solid evidence from doctors that they are disabled or vocational, something to prove their diagnosis, you should get it now, because they'll get a much bigger check than they would have gotten through SSI, for most people. So it doesn't affect your Social Security. It doesn't affect your wife or husband's Social Security. It's just more money to the family. So, but it has nothing to do with, if all your child is going to have is SSDI, you don't need to worry about special needs trust unless, we're looking at Medicaid or Medicaid waiver. But in terms of the money, the income, you don't have to have it's okay for them to have this income. All right, and you don't have to be poor. You don't have to have a special needs trust to get SSDI. Once you get SSDI for 24 months, you get a Medicare card. So this program is clearly part of Social Security. So the S and the S stands for Social Security, and the D and the I is disability income. So once your child has SSDI, either on their own work record or through a parent's work record, that's when the parent dies, retires, or becomes disabled. After 24 months, they'll have this Medicare card. If the client walks into my office and that's all they have, I'll say, look, you were barking up the right tree and you were right to be concerned, but relax, you don't have to be concerned on this right now. Maybe later, and maybe we should still do the planning, but you don't have an emergency if you're not on a benefit. These don't require that you have no assets. All right, the two at the top, however, you have to be poor, and you literally have to have less than $2,000. Well, $2,000 is not very much, and you have to think about, well, where will let's just say the child, instead of me saying son, daughter, brother, sister, I'm just going to say child. But if the child, let's think how the child might receive assets. Well, the biggest, most obvious way is when a parent dies. When a parent dies, the child is going to get an inheritance. I'm going to go over that in just a minute, and I'll finish this and then we'll do that next. But SSI, you have to be poor and disabled. This year, the maximum is $794. If you get just $1 of SSI, you get a Medicaid card automatically. They're linked. Now, this is federal, this is state, but most of the state Medicaid dollars come from the federal government. This is how they can control some of the rules, like estate recovery and paybacks, highway dollars. When I was a kid, you could drive at 15 and drink at 18. And some of us squeezed that before that even happened. Well, now you can't drink until you're 21. Well, how did that happen in a city like New Orleans? Well, it was, if you don't raise your drinking age to 21, you're not getting this money. That's how simple. That's how that happened. Okay, so anyway, the federal government has rules. They have a base Medicaid plan, and all the states have to take it as a base, and then they can tweak a couple of things. So Louisiana has a Medicaid plan that's just like anybody else's, with a couple of little subtle distinctions. So Medicaid is something to fight for. It's free medical care. It'll cover things. It's a payer of last resort. But if there's health insurance or Medicare and there's co-pays or things that are not covered, well, then Medicaid is there. Or if the parent hasn't died, retired, or become disabled, you're in your 50s and your child is in their 20s or 30s, they're not going to get SSDI if they've never worked themselves. So these are the two you'll be fighting for. But the two at the top, where you have to be poor, that's where the special needs trust planning comes in. And just to dispel any myths or mysteries, special needs trust, in terms of qualifying your child for benefits, it's just a receptacle to hold assets where neither the state or the federal government, if they're run properly and funded properly, they just can't count what's in there. It's like it doesn't exist. It's a rainy day nest egg. They're treated like they're poor. So that's why most people are doing special needs trust, is to preserve these two at the top, not the ones at the bottom, the two at the top. So you gotta get this little chart down, or you're just going to go back and forth. You got to know the distinction between the two. Okay. All right. The next thing up in your materials, there's a little chart. This is just something I use. It makes it easy for me to explain to clients what's going on. Because if you talk in abstract terms like your estate is going here and we're going to put it in a trust, they don't understand. The client doesn't understand, well, what does that mean? Well, at the top of this diagram, I've got a box in the middle, two boxes to the side. The SEP is abbreviation for separate. And then on the bottom, I have a will and then a trust within the will. So this particular trust would be a testamentary trust because it's in a last will and testament. So we're not hiding anything in the name. That's just what it's called. In order to do this kind of planning, look, some of you were single, some of you were married. So if you're single, what we could do is just, fold the chart in half and we'll only have one will and an estate. Okay, so for married couples, everything you have acquired, just to preface that, estate planning attorneys have to know divorce law, community property law, separate property law, corporate law, all these things. You can't be effective. You can't say, well, I'd like to address that, but I'm not sure about this. You have to understand all this, and so do you, or you won't be able to properly plan. I won't ask for a show of hands, but a lot of wives out there, husbands, think they inherit one half of the husband's estate. I don't know how that got started. I call it street law. But if you're married and your husband dies, you inherit a goose egg. You get nothing. Now, there may be a life insurance policy, and if you're the beneficiary, but that's life insurance. That's not part of your estate. There may be a retirement plan, and if you're the beneficiary, you might get that. But wives do not inherit from husbands, and husbands do not inherit from wives at all. There's no inheritance at all. Now, there is a usufruct, which is the right, and again, you could change this with a will, but if you don't like these apples, that's something you might consider a will. If you have a disabled child, you should consider a will, because if they inherit from you, they're not going to be poor, and you're going to lose the benefits. But what happens when a person dies, let's say they have children, the community property, this box at the top, you could put H and W for husband and wife, or your name and your wife's name, or your wife's name, whoever you are. And we're going to, there's two plans. There's the husband's plan and the wife's plan. Apologize to the single people. You just have to bear with it. Now, so the husband, let's make the husband on the left. I'll just put an H there. So I have an H and a W. So let's just think for a minute, never mind the wills. Let's just imagine that there was no will. Actually, now I'm going to have to use a chart. So here we are. This is the same H and the same W. And let's just say there's 3 kids. If the husband dies first, his whole half of the estate, let's just say there's 3 kids, 1, 2, and 3. Let's make 3 the disabled child. This whole half of the estate, and what is the community estate? It's everything you have acquired, either one of you has acquired through your own effort, industry, or skill. I'm standing, I just, on the way here, or as I was sitting down, I was doing something that was a billable matter. Well, that check's going to go to my firm, and eventually it'll trickle down to me into a paycheck, which is, anyway, my wife owns half of that check, even though she's not here. She doesn't go to the office. She doesn't practice law, but it's half hers. So if you spend it, it's gone, and then it doesn't matter. We don't have to plan with it. It's gone, it's gone. So if you take a cruise or whatever it is, right? So you don't worry about those dollars. And of course, if you don't want your husband or wife to get anything, you could just spend it all and they won't get anything. All right, so I'm kidding about that. Don't do that. But if your husband dies, or if you're the husband and you die, these 3 kids will get your entire estate. But, so I'm just going to depict it like that. The wife, and again, I don't mean to sound chauvinistic here, but it's just easier for me to explain with the husbands usually die first. It's not always the case. The wife will have sort of a little force field around it. And so they don't really get it where they can show up and say, give me my share. Because the wife has a usufruct. And a usufruct, it's just a Latin word. I'll spell it big up here. I don't know if it'll help any, but it's of course, everything I'm saying is in that outline in a more thorough fashion. But a usufruct, it's one of those Latin words. If you remember the My Fat Greek Wedding or whatever it was, and they talking about the roots of the words. Well, this is Latin, and the roots are usus and fructus. And that's part of the ownership of any item, the right to use it and the right to the fruits. Fruits are interest and dividends. If you have the usufruct of a CD, the interest is the fruit. Or if you own a fourplex or a duplex, the fruit is the rent. Right? So what this wife would have is, look, this could be where it comes in, the street law. The wife already owns half of everything. So maybe that's how it got started, I don't know. So what I'm going to do, and you don't have to do this, but I'm just going to draw a couple of little boxes, a house, and a couple of dollar signs. Okay, so it doesn't matter if that box is a toaster or a camp on a lake or a piece of property. It doesn't matter what it is. If it's community property, if it was acquired during your marriage from the time you said I do, it's on this imaginary line. Another street myth is, that's not hit. I'll handle it. Sometimes not sometimes, but all the time, I'm doing successions for people, which is just a process. We're going to talk about that too. Probate is a synonym for it. People think that if the husband is not on the account, then it's their money, and vice versa. No, it doesn't matter whose name is on an account. It doesn't matter whose name is on a car registration. None of that is relevant. You can bet your last dollar if there's a divorce, they're going to account for all of that stuff, and each side's going to get an equal share, and there may be some horse trading, but names on accounts are irrelevant. So it's just the issue is not whose name is it in, because there's really no such thing. I want to put it in my name. People say that all the time. I want to get it in my name, but that's not a legal thing. We look to see who owns the asset, not whose name it's in. And so every little asset you own is on this imaginary line. So back to our same little discussion. We'll pick on the husband here first. I'm making him the orange guy. So let's say his estate goes to if you're following along on your own little deal, I kind of do this one at a time. And then if I was explaining it to you across the desk, this is exactly how I would do it. We got to look at the husband. We don't look at both the husband and wife at the same time. We look at each of you individually. So the husband dies, kids get his half, a third each, but they can't show up after the funeral and say, give me my third, because the wife has this little force field that we call the usufruct. And of course, it's the same thing, exact opposite if the wife died first. Now, that usufruct is a little on the chintzy side. It's the law gives it to you, but it ends at remarriage. So there are people out there living in a house, and the kids may or may not know that they inherited half of that. This is without a will. They inherited half of that house when their father died, and the mother, let's say she's remarried. Well, they could literally come up and say, look, congratulations on that, but we would like our half of the house. The wife does not own the other half. She doesn't have a usufruct. So where I started with all this is wives don't inherit anything from husbands. Husbands don't inherit anything from wives. And I don't know if that's shocking or not. Now, you can change it. You might say, this husband might say, well, wait a minute. I want to take my half and leave it to my wife. I just want her to have everything. So instead of looking like that, half orange, and I guess we'll make her purple. Instead of half orange and half purple, if the first spouse dies, you might have a will that says, I'll leave everything to my husband. And the husband's will say, well, I'll leave everything to my wife. And then that's fine, but for forced heirship. If you have a disabled child, you can't do that. So again, how does a disabled child end up with funds? This is the primary way, because the husband or the wife dies without a will, and so it doesn't matter. You can't say, oh wait, let's just say his name is Johnny. Johnny can't have any money. You can't do that. You can't be an ostrich. You can't hide from it. He can't disclaim it. It's just automatic. At the moment of his father's death, Johnny's already got it. The lawyers will push the paperwork later, but it happens by law, by operation of law. So the thing there is, we need to intercept those funds. If we want to keep Johnny poor so that he can get SSI or Medicaid, doesn't matter if it's just SSDI or Medicare, we have to put something in between that husband and Johnny, and that's a will. And so at the bottom of the little chart, this is why I've depicted this. There'll be one will for the husband, one will for the wife, and the husband, if he has a disabled child, or really trusts are good for any children, the will have assets go into a trust. We'll probably do something for the wife that's better than the chintzy usufruct that ends at remarriage, or we might make it worse. We might say it'll end at remarriage or cohabitation. Alternative, you might say it lasts for a lifetime even if there is a remarriage. So that's a question for y'all. That's just a quick digression. Sometimes that married couples live longer than single people, and if your child is, just like Karen alluded to, is getting older and may outlive you, well, if getting remarried keeps them on the planet longer, maybe it's not such a bad thing. You had a question, Eric?
Yeah, Patrick, how does that, do you ever see where maybe an inheritance is so huge that they say, well, you know what, I'm not worried about Medicare and Medicaid anymore. My son, my daughter, or the person I'm going to be caring for doesn't need those benefits anymore.
Yeah. Okay. Well, I would say if a client came in and they had $5 or $6 million, I would say your child's probably going to be okay, and they could pay for things privately. Now, some of the services are not available. Like some of the things Stark has, I don't know that you can walk in there and write a check, because it may be that they're providing it through a certain type of waiver, a supports waiver, or an adult. It just depends on where their funding comes from. So the things you can get through these agencies are not always available privately. But yes, you're absolutely right. If there's...
What I'm thinking is if that happens, if the scenario happens and you have to go and activate a special needs trust, by someone to give a service such as yours, then, in the content of that special needs trust, the money can only be spent on A, B, C, D, and E, and so on. But if I just say, okay, well, I don't want to rely on the government for benefits anymore because this person's inheritance is so huge, she doesn't need it anymore. And I want that person to be able to have whatever he or she wants.
Yeah.
Rather than just this select list that the federal government says you can spend that money on.
Yeah, well, there's no, yeah, well, you can do that. And what you do is you tell your trustee, let's say you do a will, and your brother's the trustee, you say, look, if it's Joey, if I die and Joey's either not on the benefits because he's just on SSDI or Medicare, or he doesn't need the money, just ignore all that special needs trust stuff. That's what you do. The trustee does not have to follow these things. Now, there's a big myth about that. People say, well, you can only use the trust for this or that. You can't use it for housing. You absolutely can use it for housing. All that will happen is instead of getting the full SSI, let's say they're just on SSI, they'll just reduce it by 1/3. And it's, give us a break. You got a free place. That $794 was to help pay for your housing, and you have free housing, so don't be greedy. We're gonna knock it down to 2/3. So that the trustee in your particular fact pattern could just ignore that. But let me say something about special needs trust. The name is a bit of a misnomer, and it's, it used to be that you would hear people say, well, he's a special child, or this is a special school. That's not where the special comes from. The synonym for the word special is luxury. You could put your son, can I use Joey again? If Joey wanted to go on a rocket to the moon, you could use that special needs trust money and put him on a rocket to the moon.
Recreation.
Exactly. It's a luxury trust. The purpose of the trust is to make your child's life nicer and more enjoyable. Don't worry about, oh, we can only buy a loaf of bread here, we can only do that. No, it's just the opposite. You use the public benefits to pay for your basic needs, your food and your shelter. We say clothing too, but that's what you use, that's your foundation. You get that from the government, and then everything else is gravy. So entertainment, recreation, adaptive equipment, a van, all those things. So the synonym for the word special in a special needs trust is luxury. In fact, you've probably heard the expression supplemental care trust, and that's a little bit more descriptive or more accurate because it's supplementing the basic care. All right.
Also, that scenario you gave for person one and person two, child one and child two, does that scenario, the legality of that change in any way if 1 and 2 are stepchildren?
Stepchildren don't inherit from a parent at all unless the parent adopts them. There's no stepchild inheritance. Okay, now, if you can get into complicated situations where you have half brothers and sisters, but anyway, so let's say this guy, he recognizes that we have a problem here, and that is, I've just met with him, and I said, now, Mr. So-and-so, if you die without a will, Johnny is going to get a third of your estate, whether he wants it or not, whether you want him to have it or not, and whether it messes up his benefits or not. We can fix it. It's real easy to fix. You just need a will, is all you need, with a trust in it. But you see, when if this mother remarries, the usufruct ends, and then boom, Johnny's got it. Now Medicaid, I have not seen them give Johnny a hard time as long as the parent that's alive, the surviving spouse has that usufruct. But when that usufruct ends, they can give Johnny a problem. But this whole problem is so easy to solve if this couple would just do wills. Because the will can say, I leave Johnny's share into a trust, and Medicaid or SSI has to put blinders on. They can't count it. And they may ask you how you administered it. They may want an accounting. They may want to make sure that it's completely discretionary. So a lot of the wills out there on the street with trusts in them say, I leave my estate to my children in trust. They get 1/3 at 25, another third at 30, and the rest at 35. Well, that's exactly the wrong thing that you would want for Johnny. For Johnny, you have to say, I leave it to Johnny in trust for his lifetime. And then there is no point at which the trust dissolves. Because if there's a point at which the trust dissolves, like he gets a third, well, Medicaid can say, you got too much money. This is for poor people. Get out of here. What are you trying to pull? You're not poor. All right, but you can have millions of dollars in a trust that they can't count. I would just say, if you got that kind of money, you probably don't need it, unless you really can't find the services. Okay, so speaking of these other two kids real quickly, there's no reason not to consider a trust for them as well. It'll just have different provisions in it. My own father, he's 84, he's an attorney in New Orleans, claims he's retiring, which means he works 4 days a week. They're making him stay home on Friday. I guess they don't want to be charged with elder abuse or something. Anyway, so my own father has a will that leaves his estate to the 4 of us. None of us are disabled. Well, why would he do that? Are we bad kids? Are we going to mismanage the money? Are we addicts? Or, what's going on? Well, no, it doesn't make him a mean parent or us bad kids. It makes him a smart parent. And the reason is this. Anything could happen to me. I could hydroplane, run across the interstate. I was in a 40-car pileup in Slidell a long time ago. My son and I were going duck hunting, And I'm telling you, it wasn't just people say, oh, you shouldn't have had your brights on, or you should have done this. I was driving in my vehicle, and it was a combination of smoke in the marsh and fog, and I'm telling you, it might as well have been a bucket of, DeVoe paint poured down my windshield, because all I could see was the space between my eye. It was just as white as this piece of paper. And all I could do, I slowed down, I opened my door to see where the line was, and I got into the neutral ground. Anyway, the point is, anybody can have an accident. Let's say I accidentally run over Morris Bart, Gordon McKernan, and they're all in a van going to get an award for making the most money. Well, if I run all of them off the road, their family's going to be some mad because they've been living on that too. Well, I don't have enough money to even come close to satisfying that claim. I don't have enough insurance to come close to satisfying that claim. So the last thing my father would want, or I would want, is them to not only take all of my assets, but take that too. See, all he had to do, it's so easy to solve, is have a will with a trust in it, because any of you could benefit from a trust. It just has to have a couple of sentences that are important. It has to be a spendthrift trust, and you cannot be your own trustee. So in our instance, it's 4 of us. It takes a 3 out of 4 vote. I need to be able to stand up in front of a judge here in St. Tammany and say, Judge, he said, what about it, Mr. Riso? You got Morris Bart, Gordon McKernan, they're mad as hatters out there. They want money. What about that inheritance you got from your father? I need to be able to say, I'm sorry, Judge, I can't control it. I'm 1 of 4, and they said no. And it's case dismissed. So that money's protected forever. So don't feel like trusts are just for kids with problems or kids that are disabled. They can be for any kids at all. Now, if you be careful who you select as trustee. Some people let the job go to their head, even though the idea is to dole out the money for anything the kids need. Some of them are more difficult than others, particularly professional trustees. But in our case, we're the trustees. If my sister says no to something, well, I could say no to her. So she's not going to say no. All right, that's the built-in checks and balances. All right, so this whole thing we just spent all this time on is, first, you got your benefits. What are we fighting for? There's a couple of them you have to be poor, like the waivers. You have to be poor to get it, and that's all part of Medicaid. But it's the state, this is where the biggest problem is what happens if you die? Now, there are other ways your child might get money. Morris Bart might run in the back of you while your child's in the back seat. He could have an accident too. He's a public figure, so I can joke around about him. All right? It's not slandering. Okay? If he's not a public figure, I don't know who is. All right? Okay. Let's say Morris Bart runs into you and your child's in the back seat, your child gets injured. Well, I call that a hot potato. The kid's got money, the kid has a claim, it's worth X $1,000. If it's more than $2,000, that kid can get knocked out of the Medicaid program. So what do? Before that case is settled, you have that child assign the interest in the lawsuit to a special needs trust. It'd be a different kind. It won't be a testamentary trust. A testamentary trust lives in a drawer or a safety deposit box or a lawyer's office safe until you die. A will is just a donation at death. Just like a donation during life, it's just that it kind of lays there in suspense until a certain trigger, and the certain trigger is your death. All right, so, but if your child has a hot potato, we got to do a different type of trust. So, benefits, what's going to happen? Can we just hide and avoid the problem? And can we just say, we're going to leave everything to my wife? I'm going to make it go from, orange and whatever that is, purple to all purple, or half orange and purple to all orange. Can't do that because of forced heirship. I didn't really spend any time on that. Forced heirship is any child under the age of 24, which means they could be 23, 364 days old, they're not yet 24. That child's a forced heir. You can't cut them out, you have to leave them something. Or a child of any age that's permanently incapable of taking care of their person or their affairs, they're forced heir. So you might have a son that's 40 or 50, or a daughter that's 60. She's a forced heir. And it's, you might have children that are fine today and they become forced heirs because they were in an accident or something, or afflicted with some illness. So you have to think about forced heirship. How might a child become a forced heir? But if they are, you just have this prophylactic measure in place that says, well, wait, we're going to let it flow in. We're going to intercept the problem and let it flow into the trust. That's how easy this is. So let's forget that. Does anybody have any questions about separate property, community property, forced heirship, any of that?
Patrick, I have a question about the look-back period.
Okay.
So for special needs trusts for individuals with developmental or intellectual disabilities, the look-back period does not apply.
Right. It doesn't.
An elderly person who has a trust, the look-back does apply. Is that correct?
Let's take Suzanne's question and let's seize the opportunity to talk about hot potatoes. That's just what I call them because it's easy to remember. You know, oh wait, we got money here. There is no will with a trust in it. We got in a car wreck. It doesn't matter where the money came from. Your child could find the money from that guy that, I can't remember, it's DB something, that jumped out of a plane, and they never found the money. Y'all might be hiking on a trip, and your child finds the bag, and I think there's some treasure rule that will let the kid keep it. Anyway, doesn't matter where the money comes from, it's just money. So what do you do with it? That particular child, as long as they are under the age of 65. What if they're 66? We didn't know about this rule. They just turned 66. Well, they're out. They can't do it. It's just like it takes 10 yards to get a first down for the Saints. You can't say, come on, we're at 9 yards and 35 inches. Nope. The rule is 10 yards. In this particular case, the rule is you have to be under 65 to Wait, what is it? I'm sorry.
35 inches, you have the first down.
Oh, wait, because of the way they spot the ball? Okay, right, anyway. It depends on what team it is, not the Saints. It would be whoever they're playing, sure. Okay, all right. I get the sense that everybody hates the Saints and LSU whenever they're on TV. I don't know, unless it's our announcers. But you got to be under 65. You have to be disabled. And for a minute, you got to wonder, we're going to talk about this too, and that is, if a child has a hot potato, and you know about this issue, that they have to be poor to get those benefits, see, it all ties back together, you got to act fast. The month they receive this hot potato, it's considered income. But if you're still sitting on it, and you're watching it in a bank account, you put it in a savings account, the next day, the following month, it's an asset. And if you're over $2,000. So you got to act fast. There is exceptions. Sometimes people don't know they have the hot potato. Let's say they bought a lottery ticket and it's a winning number, but they washed it in their jeans. I used to do that all the time when the lottery first came out. I could have been a millionaire if I'd have just not washed everything. If they don't know, well, then that clock is really not ticking, if they really don't have access to the funds. All right, so, and I'm leading up to what Suzanne was saying. These Medicaid rules apply to disabled people. It's called long-term care Medicaid, and this is a waiver. Not just a Medicaid card where you can get your prescriptions or go to the doctor and not have a copay. That's all a Medicaid card gets you. And there's certain things Medicaid doesn't pay for. So I'm not going to stand up here and say what it does and doesn't pay for. A, I don't know, and B, what difference does it make? If they pay for it, good. If they don't, too bad. So we're not going to lobby the legislature to have them expand what Medicaid pays for. It's a federal program. But if it's the waiver, we're talking about the waiver, and this person is under a Medicaid waiver, then the rules for your grandmother in a nursing home are exactly the same, except the look back. All right, so. And I'm going to explain that. What is a waiver? A waiver is they are waiving the requirement, the state is waiving the requirement that your child be in an institution. Hammond State School or whatever it was. That's what they're waiving. So ordinarily, to get this kind of round-the-clock care, you got to be in an institution. You got to be there where they can walk up and down the halls and handle these problems all under one roof. Well, no. There's a bunch of reasons for this, like the Olmstead case, and just financially, it makes better sense to care for people in their own homes. Just look at what it costs to house prisoners. But the waiver, despite what you may hear on the street, they're not waiving the asset test, they're not waiving the income test, they're waiving the requirement that your child be parked in an institution in order to receive that level of care. Okay, so now, how do you get those waivers? Well, it used to be a waiting list, and I could stand here and say, well, look, they're serving people that applied in 2009. Well, I can't do that anymore, and that was hard enough to keep up with anyway. I'd have to call the state and say, where are you on the EDA waiver? Where are you on this waiver? And they'd tell me, but now it's a single point of entry, and y'all know more about this than me, but it's more of a triage. Those who really need it, I mean, if your 8 is enough, and Dick Van Patten died and the wife died, if you got 7 brothers and sisters to take care of you, you're kind of low on a totem pole, no matter how. It's based on level of need. That's in your outline somewhere. And I don't know what that means, Suzanne. Does that mean are there enough people with that highest level of need that really have no one to help them? Are they taking up all of the slots? I don't think it's that bad. Okay. Now, let's say we're putting your granny in a nursing home. We don't want to, but she asked to go. She's bored at home. She's seen The Price is Right. Let's make a deal. She's going crazy. She wants to socialize. She's always wanted to sing and play the piano in front of a big crowd. So and I had a grandmother that used to do that and play the drums at the Christopher Inn Apartments in Washington Square Park. Anyway. And we'd go over there, and I can remember those eyes on me. There'd be people sitting in that lobby, and you could feel them looking through you because they were just sitting down there. But you know what? It was better that they were sitting down there talking than sitting in a room somewhere by themselves, as far as I'm concerned. So nursing homes are not all bad, but if you have to put a parent or a grandparent or a child in a nursing home, if you don't want to pay the bill, which is about $6,000 a month, you can get it paid by the state. You just have to be poor. It's for poor people, not rich people. If you got $1 million, you write the check. And another myth is, well, I don't want the government, and I represent a lot of elderly people, I don't want the government to take all my money if I go in a nursing home. They don't take your money. They don't take all your money. You can keep all your money. They're just going to send you a bill once a month for $5,000, $6,000. That's it. And if you got Social Security at $2,000, you got to figure out where you're going to get the other 3 or 4. They don't come and take all your money. The government can't seize your assets. This isn't Russia or whatever, or Cuba. You can keep all your money. You just can't get free nursing home care because you're not poor. Well, how do we make Granny poor? Well, Granny, we can say, listen, Granny, you did well. You did great. You didn't go to Ruth's Chris every weekend. You had tuna fish once in a while. You didn't go out on the town. You saved $300,000-$400,000. Congratulations. But you know what, folks? That's not enough to pay for long-term care. It's just not going to last very long. Every one of us in the room, there's let me see how I'm going to do this. There's 3 ways for us to pay for long-term care. I'm going to just leave this there because I need it again. But we can be let's see. Let's start with very poor. We could have. Let me start over. All right. Poor, meaning you have less than $2,000. You can have long-term care insurance, or you could be rich. And what do I mean by rich? Well, I would say if you have $2 million of investable assets, you could find a financial planner that could probably generate that or create about $100,000 a year, and that ought to be enough to pay for sitters around the clock. You could have a move-in, have a night shift, day shift. They'll probably room and board. They'll probably take $50,000. I mean, I'm not saying that's for sure that's out there, but if you're rich, you can pay your own way. You don't need to know anything about Medicaid. It's just a question: what is rich to one person is not to another. But a couple $1 million, you probably don't need you can go to a nursing home and pay your own bill. But if you're not rich, we got to take that off the list. And if you have $200,000-$300,000 or $500,000, I wouldn't consider that rich. Long-term care insurance. By the way, if you can qualify for it, you really only need a policy that lasts 5 years. And this is all related to that look back. Because if what they say is, look, you had money, you gave it away, based on this look back period, you're disqualified. Well, the longest you could be disqualified if you got your noggin on and you're thinking straight, and you don't apply for Medicaid for 5 years, which if you give away 100, here's the rule. Let's see, 5,000, 5 years, that's, right, so $60,000 a year, that's $300,000. If you give away more than $300,000, do not apply for Medicaid within 5 years. This isn't disabled people. We're going to come back to the hot potato and a special kind of trust. If your grandmother applies, let's say she gave away $1 million, well, they will say, welcome aboard. We're not going to take all your money. We're just going to give you a bill every month. And when you're done, it's a penalty period, they call it. Well, how long does that penalty period last? It's a simple equation. It's the amount of the gift divided by 5,000. And so that's how many months she's on the bench. So if she gave away $1 million, what is that, 200 months? Does anybody want to help me out there? 1 million divided by 5,000, I think that's 200 months, which is what? 200? Okay, that's a long time. All right, so 10 years is 120 months. So in other words, she's not going to get there. She's not going to make it. So now, if that same granny would have waited just, let's say she applies 4 years and 364 days after the gift, they will disqualify her for all that time. They won't say, look, you don't want to apply for that. Why don't you go outside, pretend this didn't happen, and come on back in? No, they won't do that. They can't do it. It's illegal. So they're going to, that granny's out of the game. It doesn't mean she can't stay in a nursing home. It just means they're going to give her a bill once a month. If she dies the next month, they're out $5,000. Or the next year, they're out $60,000, whatever it is. So they don't take all your money. Now, those same rules that apply to granny apply to disabled children on these waivers. Oh, long-term care, I skipped over that. Most people don't have it, and you probably can't get it. You got to be in your 40s or 50s to get it. Then you feel like you probably don't need it. If you get to the point where you probably could use it or need it, you're not going to be able to get it. But you really only need it for 5 years. If you're lucky enough to find an opportunity, or even a life insurance policy that has this rider or an ability to convert it, you really only need it to last for 5 years. Why? Because you could, for that 5-year penalty, you just live off of that. That's what pays the bill for the 5 years. And then once it runs out, what are you going to do? Well, you're poor because you waited the 5 years. Anyway, there's all kind of ways to mess this up, but by overthinking it. If you make a gift of more than $300,000, don't wait for 5 years. Now, if the granny had only given away $50,000, don't wait 5 years. Roll her in there, shoot her in there. The most she's disqualified for is 10 months. It's the amount of the gift divided by 5,000. Why wait 60 months when you can get her in there and they'll pick up the tab at month 11? But it's all simple math here. There's a couple of equations, and so you just got to watch out. Well, but for most people, long-term care, if you don't have long-term care insurance and you're not rich, you got to be poor. Now that applies to probably almost all of us. So start saving your money, eat some tuna fish, don't go to Ruth's Chris, sell your St. Season ticket. You can try to get up to where you got a couple million, or you might want to consider yourselves, how are you going to pay for your own long-term care? Well, life insurance, of course, you could, again, I'm not a life insurance salesman, but you can create an estate with life insurance. You just have to suffer the loss of those premium dollars every month. That's the price you pay to have money to where you're rich and don't have to rely on the state. But there are special rules, and the wife or the husband at home can have about $140,000, so they can have a house. Some assets are exempt. Now, that whole 5-year look-back thing, we're back to a hot potato. Your kid got a hot potato. They found the money. They got a reward for finding a lost dog. They, whatever it is, it doesn't matter how they got the money. They got the money. It's more than $2,000. We can put it in a special type of trust, and it goes by many names, Part of the difficulty with the street law is there's so many, I just call them synonyms, but you know, PD4, you hear that. You hear under age 65 disability trust. You hear D4, but the reference to the P, the D, and the 4 is part of the statute. It's all in your outline. But under age 65, they're all the same. And the only problem with these, there's a downside. Well, there's no look back. So you could, let me make sure I'm explaining this. Just like you would go through the process of putting your granny in a nursing home, to put your son or your child on a waiver, it's the same process, except you don't have to worry about the look back period and gifts. What do I mean? If your son has a hot potato of $100,000 and we're trying to get him on a waiver, what I'm telling you is, all you have to do is put it in one of these trusts and he can go in the next day. There's no penalty, there's no look back. But here's the catch. The catch is there has to be a payback clause in that trust that says if there's any money left, and this means even if the kid dies the next day, they will go back and say, how much did we spend on that child since he was born all the way up until the date of his death, and we're taking that out of the trust. I'm working with the state on several cases right now. I got one where the trust wasn't formed properly. They didn't do the, I don't want to say too much because it may become a real case, but let's just say something wasn't done. It may become a reported case. Something wasn't done correctly. Well, I'm telling them, even though there's a trust and there's money in it, I'm telling the state, you know what? That was all invalid. That's invalid. So that trust is invalid. So we're not going to pay them anything. They're going to have to come and get it. And they can take us to court. And I think I can easily prove that the whole trust is invalid. So if the trust is invalid, how could there even be any money in the trust? All right, so I'm going to win that one. But we'll see. They may back down. But that's the catch. There's no look back, but you got to pay the piper. And it makes sense. It seems fair, except the part about going back in time. But that's just the rule. If the child dies, anything that hasn't been spent goes to the state of Louisiana up to the amount, whatever state you live in. If you live in you got 1 foot in Mississippi and 1 in Louisiana, you might owe some to each. It's whoever the state is, wherever the state where you live or receive these Medicaid services. And so instead of going to other family members, so the point of this is try to avoid the hot potatoes. The easiest hot potato to avoid is an inheritance from your will. You got to leave them something. Oh, by the way, the fourth portion is 1/4 of your estate, 25%. Now, if you have 10 children, you only have to leave them 1/10. They can't ever get a leg up on their siblings. If there's more than 4, they only get a child's fraction. But you got to give it to them. You can't say, oh no, he can't have that. He's going to lose his waiver, and it took us forever to get on that. That's not something you can say. You can't be an ostrich. You have to hit the problem head on, especially since it's a simple problem. It's incredibly simple. You do a will. And it's very inexpensive. Right, so doesn't matter. This kid got a hot potato. We know all about blocking or intercepting the parents. That's not going to be a hot potato. Not for y'all. You'll do a will if you don't already have one. But the kid got money from a grandmother, a neighbor, a brother or a sister. Somebody left them some money. Doesn't matter where they got it. They can put it in this trust. There's no look back period, but the catch is the payback clause. So this is a good spot to give you a big distinction in special needs trusts. I hear people say, oh, I already have a special needs trust. Or they call my secretary or me and say, I want to set up a special needs trust. That's just the way they say it on the street. Well, you don't want to set up a special needs trust right now, because if you do, every year Medicaid's going to say, what happened with that trust? What'd you spend the money on? It says here that there were two Big Macs. Nobody eats 2 Big Macs. Somebody else must have benefited on that trust. Anyway, do you want the scrutiny? Do you want to explain to them? No, you keep your own money in your own pocket, and you can give it to your child when there's no more time left because you're not here. That's when you got to give it to them. But I would not put any money in a disabled child's name or in a trust for their benefit for any reason, not while you're alive. unless you feel like you've got a problem, you're a gambling addict, and you don't want to blow it all. Lock me in a room, take my money. I got to take care of my son. Okay, how often is that going to happen? It may have happened, but it's not very regularly. All right, so hot potato, you can make them poor, no look back. The distinction between the one with the parents and this one is, this is somebody else's money, a third party, we call it. The parent's a third party, the neighbor's a third party, the aunt, the uncle. Whoever left assets to the child is a third party, but that's not relevant unless, there's got to be a third party trust. There's got to, before we get to the kid, I can't, if they're going to film this, I have to draw one of my stick people. All right, okay, right. Okay, so this is the kid. All right, so we're trying to, before this kid ends up with money, we need to intercept that money and just have a trust where it goes here, it's not touching his hand. He's got it, it's just for his benefit, it's held in an account in the name of the trust instead of his name. That's all it is, and there's a trustee that manages the money. That could be your other child, it could be a spouse, it doesn't matter. The point is, it's not his money yet. We're doing the planning for it now. We're going to intercept it before it gets into his hands and becomes a hot potato. That's called a third-party trust. That includes you parents. However, if it becomes a hot potato, A, because you didn't have a will, B, you got a personal injury award, however you got the money, the only thing we can do, well, there's actually now one other thing we can do if it's under a certain amount, and that's an ABLE account. But you got to put it in this kind of trust if you're trying to preserve the child's benefits. What if they're not on SSI or Medicaid? Don't worry about it. It's not a problem. There's no asset or income test for those two benefits. And again, if they'd just done some planning, it wouldn't have been a hot potato and we wouldn't have this payback clause. We could say, I'll leave this to Johnny, but at his death, I want it to go to Susie and Mary, his sisters. And you can control where it goes at his death, as opposed to going to the state. Yes, ma'am?
Excuse me, I have a question. How long before the hot potato gets cold? Or how long do you have to make it not a hot potato?
All right, well, assuming you have access to it, even if it's sitting in the lawyer's trust account, that's counted as if you have it. You have the month of receipt, it's considered income. All right, well, for Medicaid and SSI, the two that you have to be poor to receive, there is both an income test and an asset test. For the asset test, if you receive money, the month you get it, it's considered income, and you might flunk the income test. Big deal. The only penalty there is you don't get the $794 for that month. It doesn't even matter if it was $1 million. All they'll do is they'll dock you $794. But if you're still sitting on that money on the first day of the following month, it's an asset. That's when it's a problem. So if your child ends up with a hot potato, or they have one now, you might consider doing one of these trusts, and unfortunately, it just has to have that payback clause. Now, let's say this fictional kid, let's say he had a father, and the father left him, some of those orange assets in a testamentary trust, which the Medicaid, SSI, they can't count it. There's no payback clause. Let's say that that same kid, let's see, well, I'm not even exactly sure where I was going with that, but he could have a combination. He could have I know what I meant to say. This is a third-party trust. This one, we're going to send the money to Susie or Mary. Well, which money should we spend first? This money or that money? The money in the trust with the clause that says if there's anything left, it goes to the state. You don't have to get up too early to figure that one out, right? Spend that one, and then you have more here. It's just money. So don't, unless you're just very generous and you want to help the state. But you just spend that down first, and hold on, Eric, I'm going to get you. Let's just say that you spend it all. What happens then? Well, that's exactly what the state gets, 0. Go ahead.
I wanted to go to that step, to that level of that special needs trust, and then you make that trip to the bank and you say, okay, a special needs trust, I want to open up a bank account that's hitched to this trust. Basically, it's a glorified savings account, and you spend that money accordingly until it's all depleted. You close the account, and then the special needs trust is no longer.
Right, we're talking about a self-settled, under age 65 PD4, the one that was funded with the kid's own money.
Well, the kid's money that he received as a result of his one parent's dying.
Oh, no. Well, on that one, the trustee would go and take those funds instead of opening an account in the name of the kid. Maybe this is what you said. Yeah, they would open it literally in the name of the trust. If you have a trust inside your will, usually the first section of it's going to be a name. I get even my own clients call up and say, look, I need the name of the trust, and it's under section 1 and it says name, and it's got the name, but it's not hiding there. But that's how you would open the account. But yeah, it's a glorified savings account, and you can spend it any way you want. There's no...
It's $10,000 and you spend it over a few years and you get below, I think it's $1,200 at your bank, they start charging you a service fee of $12 every month. So that balance that's left in there below that amount in your bank could actually be depleted just on those monthly service charges because you're not spending that money otherwise.
Oh, yeah, sure. Yeah. Watch out for bank service charges. There are banks that have free accounts. A lot of times it's free only if you have a certain amount of money. It depends on the bank by bank. But remember, the main thing I want to convey is that there's really two kinds of trust. Actually, several. I mean, there's testamentary, there's inter vivos, there's charitable remainder trust, there are voting trusts, there are trusts if you sell your company to your employees, and ESOP, employee stock ownership trust. We could go on and on about the kind of trust. It's not just one statement, a trust. Like that's a cow. You know, that cow is just a cow. The trusts are not just trusts, there's a bunch of different kinds of trusts. Here, the main focus should be whose money is it? Did it come from, is it a hot potato because the kid already got it and my hands are tied, this is all I can do, or we could spend it. And again, it doesn't matter if he's not on benefits. Or is it a third party's money, and those are two different kinds of trusts. The one here, all it has to do is give the trustee full discretion as to whether to pay anything. If it says, like all these old wills out there, before all the special needs planning became available, they almost always say the trustee shall provide food, shelter, and clothing and educational expenses for this beneficiary. Again, exactly the wrong thing. You want it to say it won't do that. Instead, the trustee should seek out public benefits for the health and not so much education, but that's the old wills, or the ones you would use for normal children that are not disabled, are exactly the wrong thing. So if y'all, in your own lives, if you can keep in mind whose money is it right now, if it's yours, there's a lot you can do to intercept it with the will to where it never becomes a hot potato, which would force your child or you to have to put it in that trust. All right, let's talk about this child again for a moment. If let's say he just has a physical disability, still a forced heir, but he can, he's like, oh gosh, who's the guy? He's a genius and he talks. Hawkins. Okay, Hawkins would be a forced heir. But the Rain Man, you can use the Rain Man if you want. Dustin Hoffman. All right, so Steve Hawkins would be a forced heir, even though he's smarter than all the rest of us put together. Right? So it doesn't matter how smart you are, you can still be a forced heir. Now that kid, if he's smart enough to comprehend the concept of taking his money, hot potato, and putting it into a trust, we'll just have him sign on the dotted line. Now, what if he's under 18? He's not competent. You can't sign a document if you're a legal document if you're a minor. You have no capacity to enter into a legal contract like a trust. Or what if they have a mental or other disability to where they can't comprehend this concept? Well, then somebody else needs to do it for them. And that can be a parent, a grandparent, a guardian, and here we call it a curator, or curatrix, male or female, or a court. So if this kid can't sign his own documents, you got a problem. You can't just have them put an X. They got to be competent, or you're going to end up with an invalid trust, like the case I was telling you about.